Gábor, Lukács.
Chief Justice of Canada, Justices of the Court. A regime of standardized compensation is a consumer protection measure to remedy the power imbalance between airlines and passengers. What hangs in the balance today is whether Canada was acting properly when it joined 73 other states in enacting such standardized consumer protection measures for passengers traveling to and from their territories. The appellant's interpretation of the exclusivity principle forecloses such measures for Canadians, not only now, but also in the future. The respondents propose to save the APPR by narrowing the Montreal Convention scope, thereby removing existing protections available to consumers. Adopting either the appellant's or the respondent's position will harm passengers. I therefore propose a different analytical path for finding that the APPR do not conflict with the Montreal Convention. I submit 3 points. First, the convention is the floor and not the ceiling for carriers' obligations to passengers. Second, states may require carriers to waive convention defenses as a permit or licensing condition. And third, Canada's regulatory scheme requires international carriers to waive defenses that may conflict with the APPR in exchange for the privilege of operating to and from Canada. On the first point, Article 27 of the Convention, at Tab A, expressly permits carriers to waive defenses. This means that the Convention is not the ceiling for carriers' obligations to passengers on international travel. Article 26 on the next page precludes contracting out consumer protection provisions, which means that the convention is actually the floor. Contractual provisions more favorable to passengers are expressly permitted by Article 27 and are not preempted by the exclusivity principle. On the second point, the imposition of consumer protection measures as licensing requirements on commercial activities is a permissible exercise of a state's sovereignty. Requiring carriers to waive convention defenses in exchange for the privilege of operating to and from a state is consistent with the conventions. If you turn to Tab C, for decades, the United States has been requiring carriers holding a permit to serve the US to waive the Warsaw Convention's liability limitations for personal injury for carriage to, from, or through the US, up to $75,000. This is referenced at paragraph 156 also of Thibodeau. The appellants have not challenged the US requirement to waive convention defenses. It does not lie in the appellant's mouth to challenge Canadian requirements that are similar in nature. On the third point, air transportation of passengers is a regulated service requiring a license. Air service providers must comply with certain legal conditions in exchange for the privilege of operating to and from Canada and continuing to hold a license. Subsection 86.11 sub 4 of the Act is one of these legal conditions. It deems the obligations in the APPR to form part of the contractual terms and conditions of carriage between carriers and passengers. By voluntarily seeking a license, air carriers have effectively waived, pursuant to Article 27, any defenses available under the Convention that might possibly conflict with the contractual obligations set out in the APPR. This waiver of defenses is part of the quid pro quo for the privilege of operating an air service to and from Canada. After all, doing business in Canada is a voluntary choice. It is neither a right nor an obligation for any carrier.
Thank you very much.
Thank you, Justices.